You're watching The Legal Breakdown. Okay, so Glenn, we've got some major news here related to the classified documents case down in Florida. Prosecutors have said that they found more classified documents at Mar-a-Lago. What are the implications here?
More incriminating evidence. There is so much. There's a mountain of evidence showing that Donald Trump not only illegally retained classified materials, he obstructed justice by refusing to comply with a grand jury subpoena and return those materials when they were subpoenaed, and he violated our nation's espionage laws. And now we have new reporting based on some newly unsealed documents and some additional information Jack Smith has revealed as part of some litigation going on down in Florida, that even after the prosecutors believed and the FBI believed they had all of the classified documents, there were something like 4 more classified documents found where? In Donald Trump's bedroom, right? So you would think he has pretty, regular access to and control over his bedroom. And then there was some additional revelations about some videotaped footage of Walt Nauta during sort of an operative time frame, moving classified documents boxes around according to the reporting at Donald Trump's direction. And then it gets even better or worse, depending on whether you're the prosecutor or the defendant. There was also a discussion about deleting the very video that caught them moving boxes around. It's kind of like obstruction on top of obstruction. So
Right.
The real impediment to justice here, Brian, is Trump-appointed Judge Aileen Cannon, who today is presiding over some frivolous arguments, trying to, the defense is trying to just have her again toss out the indictment. But Judge Cannon has so slow-walked this case and has thus far even refused to set a trial date that she seems determined to just kind of catch and kill this prosecution altogether, and who knows if it will ever go to trial.
Glenn, the fact that we are still seeing crimes committed even after the initial tranche of crimes, doesn't this all underscore the need for swift accountability? And isn't that directly contrary or contradictory to Judge Cannon, what she's doing in this case by virtue of slow walking it, to your point? Trump is still committing these crimes, and yet the judge refuses to allow prosecutors to actually prosecute him for it.
Swift accountability when it comes to our national security, you would think would be of concern and perhaps even a priority for all institutions of government and the people that populate them, but not for Judge Cannon. To say that, she's not being impartial is just kind of a gross understatement. And Brian, as you and I have discussed before, the federal law says if your impartiality might reasonably be questioned, you, the judge, shall remove yourself from the case. Of course, she has no intent in complying with the federal law, and thus far, Jack Smith has shown no appetite in trying to force her to comply with the federal law.
Glenn, does the fact that some of this footage was released, I'm going to put some photos on the screen of what it looked like when Walt Nauta was carrying some of these classified documents out. Does the fact that some of this footage was released and that the general public was able to consume it to a degree, do you think that was kind of an effort by prosecutors to further pressure Judge Cannon to get this case going by virtue of showing just how damaging the information that he has is? Do you think that some of this was leaked out to the public a little bit?
I don't think it was leaked. So here is what we do when we have to litigate motions. We, prosecutors, will often use photographs, introduce them into the public record when we have to respond to, for example, Walt Nauta's absurd claim that there's insufficient evidence that he was part and parcel of the criminal conspiracy. To respond to that, Jack Smith will say, well, let me enter into the record some of the photographs that actually document Walt Nauta's participation in this conspiracy. So I don't think it was done for PR benefit. I do think it might have the fringe benefit of persuading the public when they see, with their own eyes, some of these crimes being committed by Trump and Nauta and De Oliveira.
Do you think this will also have a fringe benefit of imposing some pressure onto Judge Cannon to say, look at the raft of evidence that we have. Now it's in the public record. Now good luck trying to, help Donald Trump by virtue of, dismissing this case if that's what he wants to do?
I don't think it will impact Judge Cannon. She has orchestrated sort of the absence of a trial date. And when I say she orchestrated it, it really is beyond the pale that when she asked the parties, the prosecutors and the defense attorneys, to propose a trial date, once it became clear that the May trial date was not going to stick, Jack Smith said July 8. Donald Trump's attorneys said August 12. That would have been an easy one, a no-brainer. Just give the defense the trial date they requested. And she said, nope, I'm not going to set any trial date, and it doesn't look like she's going to set a trial date anytime soon. That, I think, should disqualify her when it's viewed in combination of lots of other decisions she's made, and she's been documented to have abused her judicial discretion in favor of Donald Trump by the 11th Circuit Court of Appeals. I do maintain that the recusal cup runneth over at this point, and I sure hope Jack Smith at some point decides to move out, file the motion, and litigate it in the full light of day, and let's get a reliable decision on whether she ought to be able to preside over this case.
Well, that actually lends itself to my next question. Does this give further justification for a Jack Smith motion to recuse or to remove against Judge Cannon?
I think it all goes into the recusal bucket. So right now, Brian, as we speak, they're litigating motions in that Florida courtroom. And let me talk about the two primary motions because they are frivolous. And indeed, there should not be an argument underway in federal court in Florida right now because these motions were so frivolous they should have been resolved on the papers. That's what we call it when there's no there. When the defense files a baseless motion, the prosecutors file their reply, the judge will resolve it on the papers. Motion denied. Let's move on. Judge Cannon won't do any of that. It really does look like she's trying to find excuses to just kind of extend this thing ad nauseum, in other words, until it makes us all sick, on and on and on into the future so she doesn't have to contend with a trial date, certainly not before the November election. Let me just touch on the two motions. So this morning, Walt Nauta's attorneys argued that Walt Nauta is being selectively and vindictively prosecuted. Okay. First of all, selective prosecution is a thing. There is a doctrine called selective prosecution. I teach this to my criminal justice students every semester at George Washington University. Here's what it looks like. The leading Supreme Court case on selective prosecution actually arose after the Vietnam draft. Remember, there were lots of people who were refusing to register for the draft. They were conscientious objectors or they had other reasons and they refused to register. That was a crime. And you know, after the Vietnam War concluded, the Department of Justice realized there were 670,000 non-registrants, people who had committed the crime of failing to register for the draft. 670,000. Guess how many the Department of Justice prosecuted?
Not thinking it's too many. 13. Okay.
13 people out of 670,000. What did those 13 defendants do? They filed motions that they were being selectively prosecuted and demanding that their cases be dismissed. The Supreme Court said, no, that's not selective prosecution. And they set a test. They set a bar that is so high for defendants to meet for a successful selective prosecution claim. And without really turning this into a legal breakdown law school class, the test is basically you have to prove, the defense has to prove that the prosecution in bringing these charges was acting in a discriminatory way in both its effect and in its intent. You have to prove the intent of the prosecution was corrupt and discriminatory. And I have never seen a successful selective prosecution claim. But I'll tell you, the Vietnam draft example, came kind of close, at least in my estimation, when I look at all of the selective prosecution claims. Walt Nauta, his claim doesn't come within 100 miles of that high bar. He's like, well, other people move the boxes. Yeah, but you move them criminally as part of a conspiracy. So that was a laughable motion, and it should have been resolved on the papers. But rather than resolve them on the papers, the judge said, maybe in a month we'll have an argument on that frivolous motion. Donald Trump's motion is in some ways even worse, and it's being argued in court as we speak. Let me just read what Donald Trump his attorneys put in a legal filing. It's one sentence. Now, mind you, he filed a motion to dismiss his indictment, claiming the language in the indictment was defective. It doesn't even state a crime. Okay, I've litigated motions when defense attorneys were contending that the language we put in the indictment was defective. In 30 years, I never had any of those motions granted. Here is what Donald Trump's lawyers put in a legal filing supporting their assertion that the indictment was defective. His request to dismiss the indictment is on grounds that it fails to clearly articulate a crime and instead amounts to a personal and political attack against President Trump with a litany of uncharged grievances, both for public and media consumption. That's not a legal argument. That is like a half-assed angry tweet. Yeah, it's an angry tweet is what it is. Yeah. And it's an embarrassment that lawyers would put that in a federal court motion, a legal filing. But instead of resolving on the papers, Judge Cannon said, yeah, sometime in the future we'll hear argument on that. That sometime is today. This is an example of how she is using every excuse to kick the trial can down the road, and at some point she's going to have to be called to the carpet over it.
Glenn, is this motion by Donald Trump basically to dismiss the charges against him? Is that the motion you were just discussing?
Dismiss the entire indictment. Yep.
Okay. Now, if she grants that, what's the recourse here? Does this actually redound to our benefit because then we can seek some type of appeal because jeopardy hasn't attached yet?
Bingo. You know, again, you're at the head of the legal breakdown law school class these days, Brian. But you know she's not going to do that. Why? Because if she dismissed the indictment, then Donald Trump and his lawyers could appeal it. No, because if she dismissed the indictment, then Jack Smith could appeal it, and it would be additional evidence that she should not be presiding over this case because her impartiality is open to question. So you know she's not going to do it. She's using these frivolous motions as a vehicle to delay, but at the end of the day, I don't believe she will grant any motion that would result in Jack Smith being able to appeal right up to the 11th Circuit.
Right, that's a good point. Well, we'll obviously stay on top of this as this process plays itself out, as Judge Cannon hands down some decision on these two motions that are pending right now. And of course, if we have any other news on both the Florida trial as well as the New York trial that's happening right now. So for those watching, if you want to follow along, Glenn and I are doing daily comprehensive coverage of all the legal news that's happening right now, and there is a lot. So if you're not yet subscribed to our channels, please make sure to subscribe. Glenn is on his way up to 1 million subscribers. This channel is on its way up to 3 million. So again, if you're not yet subscribed, please make sure to hit the subscribe button. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.